Hi, my name is Chip Parker. I'm a foreclosure defense attorney from Jacksonville, Florida. I'm on my way to my Daytona Beach office and thought I would take this time to discuss with you the importance of a default that has been entered in your foreclosure case. Now, if you were served with the summons and complaint in your foreclosure more than 20 days ago, you're in serious jeopardy of having a default entered against you. Now, if the plaintiff requests from the clerk of court that a default be entered, and the clerk checks the file and sees that you have not filed a responsive pleading or a request for an extension of time, the clerk will enter a default. What that default means is that you have admitted the well-pled allegations of your complaint. Well, that would include all of the necessary elements of a foreclosure, like that the plaintiff is the owner and holder of your note and mortgage, or that there has been a default under the terms of the note. Now, if you've seen any of my other videos, you know that I, in many of my cases, dispute both a default under the terms of the note, and I also dispute that the plaintiff is the owner and holder of the note. So by having a default entered against you, you're essentially taking away those elements of your defense case. More importantly, it also prevents you from conducting discovery and getting information from the plaintiff. The plaintiff is not required to provide discovery to a defaulted defendant. So it's extremely important to try to set aside the default. And it's very possible. A clerk's default can be easily set aside by a competent attorney that understands the rules of procedure and understands what's necessary in order to get that default set aside. So I'm going to talk to you about that for just a moment. You essentially have to prove three things to a judge in order to have that default set aside. One of the elements is you have to show that there has been excusable neglect on your part for your failure to file a responsive pleading within 20 days. Now, it's actually not that difficult to do because in almost every single default case that I've seen, the defendant was immediately contacted by the servicer after being served with the complaint, and for the purpose of trying to modify the terms of the mortgage. And in almost every single case, the servicer has told my client that if they cooperate with the modification process, the foreclosure case will be stayed or frozen for the period of time in which the modification is taking place. So most of my clients find out that, in fact, the case continues, even though they're working with the servicer to modify the terms of their mortgage. So when they explain that to the judge is going to say, okay, all right, that's going to be good enough. That is excusable neglect. Now, the next element is that you have to show that there's a meritorious defense to the plaintiff's case. Well, if you've seen any of my videos, you know that there are constantly issues of standing and issues of payment and the application of payments that can be raised in foreclosure cases. So I think that establishing a meritorious defense for the purpose of setting aside a default is also a very easy thing to do. The final element is that upon learning of the default, the defendant takes immediate steps to set aside the default. Now, this is critical. If you come and have a consult with me and I inform you that you have a default entered against you, the clock starts ticking right then. You have to take steps to move to set aside that default as quickly as possible. It has to be, in the eyes of the judge, a reasonable period of time. In other words, if you come to me in October and say, wow, it looks like a default was entered against me, and then you come back 3 months later to hire me, the judge is not going to take too kindly to that and may see your efforts as merely a delay tactic. So you're better off to jump on it right away and get involved, move to set aside the default right away. I think you would have a solid case for prevailing on that issue. And nowadays, quite frankly, when I move to set aside a default, I usually contact the other side and they will consent to having the default set aside without the need for a hearing, because we win those cases almost every single time. So, and it obviously is going to save them some time, energy, and effort. So there you have it. My name is Chip Parker. My email address is parker@jackslawcenter.com, and I appreciate you taking the time to listen to me. If you have a complaint in foreclosure in the state of Florida and you would like for me to review that file, review that complaint, scan it and email it to me. I'll take a look at it. I'll tell you what I think about your case. Have a great day.